SJC-12735, Commonwealth v. Frank Stirlacci.
Mr. Shuri, good morning.
Thank you, Mr. Chief Justice, and may it please the court. The Massachusetts legislature conditionally has exempted medical practitioners from general drug distribution liability. That, of course, is a necessary result if modern medicine is to be practiced in the Commonwealth. The Superior Court's decision below, however, extended that limited exemption to egregiously improper criminal conduct. In interpreting exactly what the scope of that exemption is, I suggest we look first to the statute at issue. And we see Mike Brief, I believe, contributed to some confusion to the exact language of that statute in suggesting the word "and" actually appears in the statute. It does not, but it does state positively what is required in order for a prescription to be valid. In doing
the statute says only that a prescription for a controlled substance is to be valid shall be issued for a legitimate medical purpose by a practitioner acting in the usual course of his professional practice, right?
Correct, Your Honor.
Okay, that's all it says.
That's the relevant
No
portion.
"and" in there, and there's no disjunctive.
There's no "and." It's correct.
So what are the elements that you have to prove?
So, suggested after prove that a prescription was issued.
Yeah.
And then the questionable element about whether it has to be a practitioner or not, Chatfield-Taylor suggested it did, and then the two that are relevant here, because the practitioner issue really isn't, that whether it was issued for a legitimate medical purpose or in the usual course of professional practice. I apologize.
And how about trying "and"? What happens if you do "and"?
Well, if we do "and," it depends how it's phrased. If the Commonwealth has to prove both of those elements.
Has the Commonwealth done that here?
I suggest the Commonwealth has done that.
Okay, so what's the difference between "or" and "and" in this case?
Well, the difference in this case is that...
Did the judge actually rule on this issue?
You know, he actually did, and on this issue too, I think my brief confuses things a little bit. I think he states the standard correctly. He does state that these are two elements that either one is sufficient. Of course, we disagree with his application of that standard.
Wouldn't it be that evidence would satisfy both, but they're separate requirements? And I think what we're asking you is where you're getting the "or." I don't know, you cited some 10th Circuit case. Is that it?
Sure. So the 10th Circuit case, which relies on Moore, which is a U.S. Supreme Court case, of course, this is technically persuasive authority. However, I would suggest in the circumstances of this case, where the Massachusetts statute almost exactly parallels the federal regulation and came immediately after it, that persuasive authority should carry significant weight, especially where the cases here really haven't addressed that issue directly in Massachusetts and have treated it somewhat differently in different places. I suggest that the most recent case to deal with the issue, Brown, 2010 case out of this court, really on one page suggested that legitimate medical purpose was all that was required for a conviction or lack thereof, and then the next page suggests otherwise.
Are you aware of any statute in the Commonwealth, criminal statute, where there's a list, a very simple sentence that Justice Link just read to you, where the government inserts an "or" where there isn't one?
I'm not aware of any other case with the parallel.
Probably for a reason, right?
Well, I don't see any other case or statute that positively lists what is required for someone to be immune from criminal liability, which is what this statute does. And the courts have said that repeatedly. The statute is listed not what needs to be proved for a crime, but states positively what is needed in order for a prescription to be valid. If those,
Can I make this a little simpler for your argument? I understand your argument, but it seems much simpler than that. Aren't you saying that what the statute says is to come outside of the normal distribution laws and have this exemption, the practitioner has to prescribe for a legitimate medical purpose in the usual course of his professional practice. And if it's for a legitimate medical purpose, but not in the course of professional practice, you don't get the exemption. If it's a usual course of professional practice, but not a legitimate medical purpose, you don't get the exemption. So either one makes it not a prescription.
Whose burden of proof is that then? Whose burden of proof?
well, I believe it is the Commonwealth's burden of proof.
Commonwealth's burden of proof, not the defendant's burden of proof.
And that's correct. And I would suggest that that's where I agree, Your Honor. That's one way of explaining it. I don't think it can be phrased entirely in terms of an exemption from criminal liability, because this court has said, no, this isn't just an affirmative defense. This is actually what would be charged, a violation of this statute. It wouldn't be an exemption to the other statutes.
In Commonwealth versus Comans, I know it's an old case, but that was just addressing whether it was usual course of professional practice, and the case was allowed to go forward.
Right. Well, there are a couple of cases that seem to hint at that. There has been some vagueness in that, Your Honor. That is my position. Not necessarily that I'm asking the court to overrule prior precedent, but to clarify how those elements work together.
Perhaps I'm being excessively simple-minded, but it is a crime to issue a prescription that is not valid, correct?
Correct.
And a prescription is not valid unless it's issued by a practitioner, it's issued for a legitimate medical purpose, and it's issued in the usual course of professional practice. And so unless all three of those are met, it is an invalid prescription.
I believe that's the plain reading of the statute. However, the only thing I would clarify is that the Chatfield-Taylor case suggests that actually that practitioner element, because of the purpose of the statute, is actually something that might need to be affirmatively proved here as well.
That seems weird, because if I were to issue a prescription in the usual course of professional practice for a legitimate medical purpose, it's still not a valid prescription, and I would think I've still committed a crime.
It seems weird to me too, Your Honor. I believe the idea is that then if you're not a practitioner, the appropriate course for the Commonwealth would be to prosecute you under the other drug statutes. So, but I don't think we necessarily, and I should clarify that Chatfield-Taylor didn't, that's the suggestion in Chatfield-Taylor. They include several footnotes which suggest we're not deciding, we're assuming this, that a practitioner is an element the Commonwealth has to require. We're not definitively saying that.
So what does it mean to be in the usual course of his professional practice? I know that was something that was challenging for Judge Mason. What do you say it means? Or I guess more precisely, why is there evidence that indicates that what this doctor did was not in the usual course of his professional practice?
So the federal case Nelson would suggest malpractice. If it's medical malpractice according to a board, then that's not, then that would be outside the usual course of practice. Coburn suggests a little bit differently, essentially that the doctor has failed even to act as a physician at this point. The defendant here acted outside the usual course of practice because he was prescribing medications without having any involvement in that decision whatsoever, simply authorizing a non-medically licensed person to use pre-signed prescriptions to fill whatever, essentially whatever individuals ask for who come into the practice.
Not
Saying
just,
this was not a question of refills or things like that? These were brand-new prescriptions for drugs these patients had never had?
Well, no, I don't know that there's a distinction that it's not a prescription if the patients had it previously. I think that the judge below relied on this these were renewals.
They were renewals.
They were renewals. And that's a question a grand juror asked, and that the state trooper explained that they were renewals. But a prescription is a prescription. And whether, because you had it in the past, doesn't entitle you to have it forever. Doesn't entitle you to have it the next time.
What
I'm
if,
sorry.
let me ask you a different question, going in a different direction. Suppose this was a medication that had the patient not receive the prescription, there would have been consequences to the patient. And the doctor is the normal doctor, this doctor is the patient's regular doctor. Would the doctor not have been liable in those circumstances for not renewing the prescription as a matter of course, even though he was wherever he was?
Well, so to be clear, the issue isn't necessarily that he wasn't at the practice.
Right.
But that, so if it's an emergency or it needs to be done, no one's saying that if it needs to be done, the doctor can't do it. The problem is he didn't here. He didn't review any of these. If the office manager.
Saying he didn't use any medical judgment, it was the
Correct.
it was the office manager who used medical
He
judgment.
wasn't even aware of what the prescriptions were going out for or who they were going to.
Isn't the problem when the judge below was looking at the usual course of medical practice and whether it was legitimate, he was, and he cited the Supreme Court case for this proposition, he was bothered by the lack of expert testimony in this case. And here we have no guidance other than, and you'll get to this, the phone conversations, which are pretty damning for the defendant. But typically, this issue is something that a layperson can't understand, right? So an indictment would be based on some type of medical expert or to tell us what is outside normal practice.
Typically it would. In this case, it goes to the egregiousness of the conduct that I suggest it doesn't have to be. The grand juror, the average person from their common knowledge has some concept of what a prescription is. They don't necessarily need to know.
If you took the phone conversations out of this and you had someone who issued a renewal and didn't see the patient, you're saying that that would satisfy probable cause?
No, I suggest that would need expert testimony. Because I don't think it's within the average person's or reasonable person's knowledge what exactly, what precise involvement a doctor needs to have in order to issue a prescription. But it is within the average person's knowledge that it requires some level of expertise, some level of involvement, whatever that may be, in issuing a prescription. And you can't just sign a blank sheet or pad of prescriptions and say to an untrained person, sign these to any, or fill in the bodies of these to whoever comes in asking for one.
Even when it's a renewal, sort of an ordinary renewal, because I don't know about you, if you're on a regular prescription, the pharmacy calls you up and says your prescription's expired, and they can automatically do this. Are they really checking with the doctor each time? I have no idea what needs to be done in the usual course of medical practice for renewals of sort of standard prescriptions. I just don't know how it works. I just know a lot of it's automated these days.
Yeah, and following up on that, Justice Kafker's question, I think, is what if the doctor has authorized, like, let's say, three refills at the time he issues the prescription? What then?
Sure. Well, I think we're not dealing with what he said to the pharmacy. Of course, if he issues, you can renew this up to this number of times.
No, wait. Renewals and refills are different. So let's be precise with the language. So if the doctor says 3 refills, right, that's going to go through automatically.
Well, I guess I'm dealing with in Justice Kafker's hypothetical that refills is an order to the pharmacy.
Yes.
And I think if it's authorized by the doctor
Yes.
to the pharmacy or even otherwise, then we wouldn't have enough evidence here. That's not what happens, though. It's not a statement of, I've said this can be refilled this number of times.
Mm-hmm.
He says, anyone comes in for a prescription, give it to them, in effect, is what he says, and leaves this. So these are not refills going directly to a pharmacy.
Are they renewals?
I believe that's the word the state trooper uses in describing what.
And a renewal, it would be a prescription that has expired and has no refills, but needs to be renewed by the doctor, correct?
Correct.
And so that's what we're dealing with here? And we're not dealing with the office manager decided to write a prescription for something brand new that the patient came up with?
Well, none of the prescriptions that actually were written were for something brand new, according to that trooper's testimony. He says that they've been treated for these before, they've had these prescriptions before. But that's not, factually, that's not a surprise, that no one came in off the street who hadn't been to this office before and said to the office manager, can I please have a prescription for this without an appointment or without seeing anyone or giving a medical history, right? You wouldn't expect that.
Right.
So the end result, I don't think, saves the doctor here, that the only people to actually get prescriptions were people who had come before and had gotten prescriptions from him
The same
before.
prescriptions?
Correct.
For the same drug?
Right.
So was there any evidence before the grand jury of the distinction between the renewal of a controlled substance versus the renewal of a typical cholesterol or blood pressure medication?
The distinction came through some of the conversations with the phone conversations where the doctor actually lays out to the office manager, because he was trying to save some of the pre-signed prescription pads, says if it's not narcotics, then you can just sign your name / my name to have these sent out. So the inference that she needs to use the actual prescriptions for that all the ones with his actual signature on them are the controlled substances.
And are all of the counts that we're dealing with controlled substance counts?
Correct.
All right, thank you.
Thank you.
Mr. O'Donnell.
Good morning, Mr. Chief Justice. Good morning, other justices. May it please the court, I'm A.J. O'Donnell, and I represent Dr. Stirlacci in this matter. I would suggest to the court that Justice Mason was correct in his decision on this point. He spent an enormous amount of time, as you can see from his decision, to make sure he got this right. And if you look, he endeavored very hard to look for guidance from other areas. He looked at the statute 94C, the Controlled Substances Act, and if you look in the beginning of that statute, the first section's up to about 30, they point to the Commissioner of Public Health, and he looked for guidance for definitions for these two terms before the Commissioner, and it didn't exist.
So he was struggling with what is legitimate medical practice, and he looks at the Board of Registration in Medicine guidelines, correct?
Yes, yes, Your Honor, that's accurate.
But and you're absolutely right. He put a lot of work into this case and a lot of thought. The problem I see is these phone conversations, and I probably would agree with you if we didn't have the phone conversations and we don't know what the normal practice is. I don't think a layperson does, but we have the phone conversations where they're talking about keeping the business afloat. There's a certain profit motive, and then there are instances where the office manager tells the physician, this person came in, I had 3, and he doesn't even ask them about any medical issues. He just basically is worried about keeping the money coming in. Doesn't that provide evidence, at least probable cause,
No,
in the grand jury stage to get over the rail?
I would say no. And in fact, even in your hypothetical and in the
It's not a
facts of this,
hypothetical, it's what happened here.
You're missing some facts, because these were renewals of existing patients who came in, and on all of these patients, they were renewing prescriptions. These weren't patients coming in with new complaints.
Oh, I know
Or
that.
patients who had some history of some illegal activity or concerns of substance abuse.
Okay, so someone came in, they're getting Oxycontin, and they want a renewal, and the physician doesn't know whether their back still hurts, correct?
Well, I presume, Your Honor,
Does the physician know whether the back still hurts?
but if you're creating a hypothetical, if someone just comes in, on that hypothetical, I don't know the answer.
Someone is a patient of this physician. They're on fentanyl or Oxycontin.
Yes.
This is what happened in this case. The physician is now in a Kentucky jail, correct?
Yes.
The patient then, the prescription has lapsed. They want a renewal of the Oxycontin fentanyl prescription, and they're given it by the office manager.
Yes.
Does the physician know whether or not this person is still in pain?
I would suggest what you can infer from the record evidence in this case is if the patient is coming back in seeking their renewal, there's nothing to suggest that they were not continuing to suffering whatever the condition was, their back
However,
condition.
isn't that the point of a renewal of a prescription for the practitioner to decide whether a renewal is appropriate or not?
Well, I think if take that a step further, Your Honor, if it's just a renewal and someone's coming in the ordinary course to ask to have their prescription renewed, I don't think the physician needs to see them each and every time to make that determination. And in fact, if you look at Judge Mason's decision, if you look at the citations to the medical board, there isn't that requirement. These are simply renewals. If someone was coming in with some new complaints or some change in their condition, that would change the
Yeah,
circumstances.
I'm not suggesting that the practitioner would have to see every patient, but they'd have to have some information about whether to renew the prescription. And keeping in mind, there's a difference between refills, because the doctor says 3 refills on this prescription, and a renewal, which is renewing the original prescription. In order to renew it, you have to have some information to decide whether to do that.
Well, I think, Your Honor, they did have medical charts. There were records. In fact, those records were presented to the grand jury.
Did the doctor have access to the medical charts?
Well, he was incarcerated. He didn't physically have those. No, he wouldn't. But
Did he consult the medical charts when he said, go ahead, let's keep the business afloat?
I don't think there's any record evidence of that, Your Honor. But
In
there's
all
also
those phone conversations with the office manager, did he ask about any of the patients?
I don't think there's record evidence to that point, Your Honor. However, I think what's important is there's also no record evidence that there were people coming in with complaints that weren't substantiated.
But isn't this, going back to Justice Budd's point, isn't this particularly of concern when you're dealing with opiates? I mean, everyone is just so, for good reason, focused on making sure that there really is a need for the renewal because of the tragedy involved with addiction. And so it's not just renewals, it's more pronounced here because of the type of drug. You gotta be really incredibly careful when you're dealing with a renewal of an opiate.
Could you remind me what the count's here for, what kinds of substances we're talking about, which controlled substances we're talking about?
If you can answer Justice Lowy first and then get on to Justice Lang, so go ahead.
The same question, basically.
Okay. Just to follow up on that point, the concerns of OxyContin, I think, is probably the question you both have. But the issue is, I think that if there's some concern with that and how that should be managed, I think that perhaps belongs with the legislature or even with the medical board. And the medical board, as we've seen from Justice Mason's decision, is silent on that. These are renewals. These aren't new prescriptions. These aren't new patients that are walking into the practice and just getting a prescription. These are existing patients who, from the record as we've seen, have been examined by the doctor. They've maintained these records. There's no indication that any of these patients have any history of substance abuse. There's no indication that any of these patients have any drug addictions. And that was presented to the grand jury. So I certainly understand your concern, given our climate. It's unfortunate what's happened. But notwithstanding, there's nothing to substantiate some concern that if you look at the case law that the Commonwealth mentioned where there's this egregious conduct, this record is devoid of that.
But it's also, sorry, did Justice Lang get her question answered? I'm not
Yeah,
sure.
I just didn't remember what the judge
You were
was.
asking about which particular substances? Yeah.
You're saying that
There were
OxyContin.
various controlled substances, Your Honor, and I think one of the most important ones
Okay,
is
that was
just-
my question.
was
It wasn't
the
just like
OxyContin.
codeine or something like that.
Yes.
I'm sorry, go ahead.
No, go ahead, go ahead.
Yeah, I guess what I hear you telling us essentially is, although we are saying, isn't there some requirement for some individualized medical judgment to be made before a renewal is done of a drug like fentanyl or oxycodone? You're telling us, well, maybe in a better world that's right, but that's not, we can't say that that's in the usual course of professional practice because there is nothing or nowhere in the record of the grand jury that speaks to that. Is that what you're saying?
That's what I'm saying. If these were renewals of existing patients who there were medical charts for, Your Honor, that had been evaluated for what their conditions were. These were patients there were some interviews to see if there was any substance abuse issues given these particular medications that they were prescribed. And the record is devoid of any evidence that there was evidence of some substance abuse or a patient coming in, if they have a 30-day prescription, coming in after 10 days or 5 days, or if there was some concern that this person was selling these medications on the street. There's none of that in this record.
Okay, but you agree that there is no that the record supports a finding of probable cause, that there was no individualized medical judgment made with regard to the decision to renew any of these?
Well, I don't know if I would agree with that, because the doctor had seen these patients. They were existing patients. They weren't new patients. So I think if you're suggesting is he required each time a patient comes in to renew their prescription, is he required to do a reevaluation or reassessment, I don't find any requirement for that.
Is there an argument that if he chose not to renew those, he should be also exercising medical judgment? A decision to not renew something that maybe cause, if a patient is without it, will cause side effects?
Well,
That also requires medical judgment to not do something in that instance.
well, if there was a patient coming in expressing some concerns, as you're explaining, I think that would be a patient, an existing patient, if it was in this case, and the patient came in and expressed some concerns about their medication or some change in their medical condition, whether that's reported to the nurse practitioner or to
I guess
member
what I'm
of the
getting at is
staff,
that
the
if the
answer is
doctor's
yes.
away for whatever reason, and the patient wants or needs a renewal, the decision to renew or not renew, whether it's an affirmative decision to renew or a decision to not renew, both decisions require medical judgment.
Yes, and the answer is yes, it does, and I think that decision's made by the doctor when he initially sees that patient and during his course of treatment of that patient. And these patients were seen over months, over years. In this particular case, these weren't new patients, and
Why did he tell the office manager to grow a backbone?
well, Your Honor, I think two things. I can't specifically answer that phrase. I would think you can infer from this transcript this was a harrowing experience for Dr. Stirlacci. He went to Kentucky to deal with a legal matter and was incarcerated. He wanted to keep his business going. I know there was some mention before.
He had the issue with the nurse practitioner who wanted no part of this. You had the office manager saying, I've got qualms about this. And you have the doctor saying, we need money, grow a backbone.
Well, understand something, Your Honor. He certainly needed to keep his business going. He had a responsibility to his employees, had to keep the business going. He was away, as sometimes doctors are. They may be away for a whole panoply of reasons. And in this specific case, and the narrow issue of this case, are renewals. These were not new prescriptions. So he was explaining to his staff how to
But aren't there different kinds, with no, he doesn't give specific guidance here. He's not breaking down, the patients into categories for the office manager. We're dealing with OxyContin and other substances. We're also just dealing with the probable cause standard. I understand at trial these things may be a totally different story, but doesn't this cross over into probable cause when you add up all the telephone conversations, the lack of individualized review, these, the sense that you've got different types of renewals, and that he's just pulling pieces of paper one after another? Doesn't that get over the hump on probable cause?
No, I don't think so. And I think the reason being is the issues that Judge Mason delineated when he looked at these particular issues, the 7 factors in particular. And if you look at the case law that's been decided by this court, by the appeals court, if you juxtapose those two, you will see that they're very similar, the factors as well as the decisions in those cases. This case doesn't rise to the level of that egregiousness in those cases.
So what do you say is required? Do you think usual course of professional practice? Do you think there has to be a medical expert on the standard of care as it relates to renewals to satisfy
Well,
sufficiency?
That's something I argued in the brief, and that's the problem with this case, because we're taking, lawyers stepping into the medical field and saying, here's what we think should be done. This required expert medical opinions. And if you looked at some of the other cases, there were experts involved. So now, lawyers are trying to decide what the doctors should be doing, how they should be operating their practices, and what's good practice. Frankly, this is like a medical malpractice tribunal, and that's how it should have been handled, because we're talking about the district attorney's office finding what they believe to be inappropriate without any expert opinion, any opinions from medical practitioners. And I think that's what the real issue is, and I argued in the brief. You needed someone from the medical field to opine on this, not the opinions of the doctors. And that's why Judge Mason worked so very hard to look into the medical field. He went to the Board of Medicine to see what they had, because the government didn't give any guidance to the grand jury as to how the medical field works, what their ordinary course of practice is, how they dispense meds, how renewals are done. The record is devoid of that, and that's the gaping hole for this case. So now we're here struggling over what do we think the ordinary course is, and how things should be dispensed, whether it be OxyContin or fentanyl. But that required an expert medical opinion. We needed some medical professional to testify before the grand jury, as opposed to just the state trooper. And the state trooper, in fact, at one point was uncomfortable answering questions about some of the patient's medical backgrounds.
Wasn't that because of HEPA? There are all kinds of rules about not giving individualized patients personal data, so I assume he's just being cautious there, right?
I don't know about that, and here's why. Because they're already past HIPAA in this case, because they're already looking at prescriptions and they're presenting some of that material to the grand jury. So I think we were past that. The bottom line is they needed some expert to give guidance, because otherwise we're substituting what we think might be right from what the medical field, who specializes in this. This is their profession, this is their science, and we should be relying on them.
All right, thank you.
Thank you.
Mr. Anderson, we've not forgotten you. On behalf of Ms. Miller.
Yes, good afternoon, and may it please the court. My name is Roy Anderson. I represent Jessica Miller. And because she's been indicted as a practitioner, I submit that all the defenses raised by my brother in defense of Dr. Stirlacci apply equally to her.
So why doesn't the accessory statute apply in this instance?
The accessory statute is separate, Judge. I think like in the federal system, they will indict as an accessory or an aider and abettor or whatever. Here, there's no such language in the particular statute. They did not have, they limited the application of this statute by the language of the statute.
Don't you have the strange situation where if your client isn't under this statute, which limits liability because it's done in the medical field, she could be indicted as just someone who aided and abetted in the distribution of narcotics?
She was not.
Right under the normal statute, and it'd be worse for her.
Maybe, but that is not what we're looking at today. We're looking at someone that was basically indicted as a practitioner, and she is not. Clearly not. I think there's no suggestion that she ever was. And the statute defines the conduct of a practitioner, tells what the responsibilities are, and what he shall issue.
But it's in a separate statute is the accessory statute that says anybody who's accessory to any felony shall be liable, blah, blah, blah.
But I submit, Your Honor, because this statute does not refer to that, I think that because of the exclusive nature of this statute that is limited to practitioners.
Maybe that's your answer, it's the exclusive nature of it, because no statute refers to accessory statute, right?
No, but they don't limit the application of the statute. Usually it's not a practitioner, it is a person.
Okay.
And they could have expanded the length and breadth of the application of the statute by substituting person, but they didn't.
Any other statutes where that's the case that you found in your travels?
Only in the federal system when they say aider and abettors and all the statutes. It's the only thing I can think of that would be comparable. And by not doing that, I think that Basically, that's the legislative intention, in this case in particular, to address the conduct of practitioners.
No other state statute you found?
No, Judge.
But she's covered by 33B and the others, and 175H2, right? Because those are no person or any person language, right?
Yes, but that is not what we're facing today, Judge. We're facing two indictments for charging her under 19A and under 9433.
So but she has not been charged under 33B for issuing a false prescription?
Yes, she has.
Okay, so she has.
Yes.
So how does she get out of that? Because isn't she covered by falsification of a prescription?
The falsification was defined as forgery, deception, or subterfuge. There was none of that in this case. There was
But
no
it says
forgery, there was no
forgery, fraud,
deception, there was no
deception.
subterfuge.
It says forgery, fraud, deception, or subterfuge, including but not limited to the forgery or falsification of a prescription.
Yes.
So if she signs his name, I can't remember, how is she signing?
She did not sign his name.
Okay,
He
she-
signed his name, and he signed the names, he gave her pre-instructions as to who was to receive what prescriptions apparently, and if they came in for the prescription, she would add that to the prescription. There's a
Go to the
limited,
body of the prescription.
to the body of the prescription. She never signed his name.
Okay, so she fills out the thing so that it looks like he's filled out the whole thing. Does she sign her name anywhere?
No.
Does her name appear anywhere?
No, it does not.
So the prescription is
Not of the
signed by him?
prescriptions at issue. Her name does not appear. It is, she's acting under his direction, not as a practitioner, but as a secretary, essentially.
But wouldn't the pharmacist think that the entire script is authored by the person who signed it? That's the uttering?
I'm sure the pharmacist wouldn't give that any thought, because the prescription is signed by the doctor. Who fills it in is probably the secretary in many of these type of situations. This is a one-man operation. He has one employee who is called an office manager, but essentially is a secretary, who turns the lights on in the morning, turns off at night, takes phone calls, and fills in documents.
But isn't it for the jury to decide all this and whether or not she's committed this crime? I hear you arguing that she hasn't.
Well, I'm saying that there's no forgery because she didn't sign anything. Therefore, 9433 does not apply. I'm saying that 19A does not apply because she's not a practitioner. And
Yeah, I'm just trying to figure out why the 33B doesn't apply, because she has filled in the body of the thing. And maybe, I mean, I don't know
that's
enough.
what secretaries do, Judge.
I just, that may be what they do, but I don't know enough to know that's true, and whether there's probable cause in this circumstance where, again, with all the background facts that we've got before the grand jury, to think that that's not what secretaries do, which is that secretaries don't fill out that kind of information when the doctor has no clue about the individual patient at all. I just don't know that's so obvious.
But that does not make it a forgery.
Well,
Forgery
doesn't make it
It's
implies
it doesn't have to be a forgery, it could be a false document, right?
fraud, deception, or subterfuge.
Yes, but it's not. It's what's the doctor's intention communicated to the secretary for her to give his clients the renewal of the drug that they had been prescribed for who knows how long based upon his relationship with the client. That is not a forgery or a misrepresentation. That is the doctor's intention that is accurately applied to the prescription. And he signed it. All she did was act as a secretary, according to his instructions, and not a practitioner.
But you agree that the fact that she was operating under his direction does not protect her from being an aider and abettor. It's not as if we have I was just taking orders, sir.
I think that would be a stretch to call that relationship aiding and abetting. As any secretary could be subject to attack on that if she was the one that typed the letter. and as secretaries do even, apply now the electronic signature to the document.
If I ask my secretary to type out a bank robbery note, that'd be okay?
A bank robbery note?
Yeah.
I'm not quite sure that would be okay,
Okay.
Judge. But in reality, this is not that type of conduct. This is standard office procedure. And she is not a practitioner, and there was no forgery, and there was no deception, because this was the instruction she was given to supply the drug that had been prescribed on prior occasions, subject to renewal, to patients that needed it while the doctor was out. Now, and I think that in Judge Mason's decision, and in other decisions, appellate decisions, they acknowledge the fact that there are times when a solo practitioner is not going to be in the office, and that leaving a legitimate signature with instructions to the secretary if someone comes in to fill it in for them. There's no sense in filling it in if they're not coming in to look for the renewal at that time, because it may be needed for someone else with a similar legitimate request. So, the other thing I was going to mention is the billing charges, submitting the false bills.
We really don't get an indication from the judge. I was a little unclear as to which ones he threw out. I think he said some of them are good, some of them are bad, I guess, right?
I am looking at it from a different direction. I am looking at it as these instructions giving to a secretary from a doctor that she works for that knows the requirements. The secretary obviously doesn't, because she's asking him on the record in the phone call, what should I do? How do I handle this? And he tells her. I submit that's a secretarial employer relationship, and the secretary is not responsible in terms of mens rea.
For all of them, as opposed to just...
For all of them, correct.
Okay.
That's my feeling on that. I had a little trouble figuring out which ones were.
Right.
I was kind of hoping you would have that.
All right,
Yeah, okay.
thank you, and we'll take
Thank
one
you
more
very
break.
much. Okay.